just to make this easy. I can see good enough. Will you be able to hear well enough?
And then Tony will do just like he did last time. Unmute that so then
Okay.
Whenever you're ready to go.
I have to wait for the prosecutor. Did you want him on the big screen?
I don't care.
Mr. Lassay? Do you care if it's on the big screen?
No, I don't.
Yeah, I didn't either. All right, we're back on the record. The appearances remain the same, but now we have Mr. Cayer by video. Mr. Cayer, can you hear me?
Hold on.
You cannot hear me.
No, because I have it on mute and
Okay.
start video. Okay, go ahead, Judge.
Mr. Cayer, can you hear me?
Yes, can you hear me?
Yes, I can. Thank you. We're here in the midst of the second phase of your trial, and although I don't think that your right to testify is the same as it is in a criminal case, during this responsibility phase, I think there's clear case law saying that you still have a due process right to testify. Is it your desire to testify in this portion of the trial?
No, ma'am.
Do you understand that you have that right?
Yes, I've discussed it with my attorneys. I
Okay.
don't feel any point to it.
All right, thank you. That was my next question. Do you or have you discussed this with your attorneys? Has anyone made any threats or any promises to influence your decision?
No.
And your decision is to not testify, is that correct?
Correct.
All right, thank you. And Mr. Eichhoff, have you had a sufficient opportunity to discuss this matter with your client, Mr. Cayer, and whether or not he wants to testify in this phase of the proceedings?
Yes, Mr. Cotton and I did have the opportunity to discuss with Mr. Cayer his right to testify today, and we believe that he is making this decision voluntarily not to testify.
All right. Thank you. Then I do find that Mr. Cayer is waiving his right to testify here today, although it's not a constitutional right like it would be in the first phase of the proceedings. He would still have a due process right to testify, and I find that he's waiving that right to testify freely, voluntarily, intelligently, and understandingly. Anything else you want me to ask of Mr. Cayer regarding his right to testify, Mr. Eichhoff?
No, Your Honor.
Mr. Lassay?
No, Your Honor.
Thank you, Mr. Cayer.
Thank you, Jake. We'll see you later.
Adios.
All right, then let's return quickly to our discussions that we were having about the jury instructions. I asked if anyone wanted to request any additional instructions. Mr. Cotton said no. What about the state? All right. So is your microphone on? Thank you. Any objection to instruction 100? Opening?
No.
No.
120, ignoring judge's demeanor. 115, objections of counsel. Any objection?
No.
No, Your Honor.
Burden of proof, ordinary. That's instruction 200. 230, circumstantial evidence. 215, credibility of witness. Any objection to those?
No, Your Honor.
No.
And then 640, mental disease or defect expert opinion testimony. There are some bracketed portions. It looks like anything regarding conflicting testimony would be deleted. And the last part,
I think he is technically court appointed. I know that.
I did look up the order to make sure that that was. So I will add his name and any objection to that instruction as modified.
And we're talking about 605, right, Your Honor?
640.
640, I'm sorry.
It should have been the page before 605.
And you indicated, what were you going to?
Strike out the conflicting testimony portion, and then the last portion about court appointed, use that and indicate the name of Kenneth Robbins.
You have no objection to that, Your Honor.
All right. 605. That's the significant instruction at this point. And there's a lot of bracketed material. I reviewed one other trial that was held with this type of an issue, and this instruction, they read all of those bracketed portions. What is your request regarding those portions?
I would ask that the first two be read. I don't think there's any evidence to support intoxication, so I don't see a need to read the next three.
Any objection to that?
Your Honor, I don't think either of them need to be read. I think the the passion or the frenzy prompted by revenge is their argument. I don't think that's evidence. At the same time, we're talking about repeated criminal or otherwise antisocial conduct. It's an argument, not any type of. There was no evidence, so I don't think any of those bracketed descriptions should come in.
I think there's clearly been evidence presented in the first phase of this trial regarding both of those, and therefore they should be included. Obviously, I understand the defense disagrees that that's what happened, but that's the jury's function, so I think it should be considered.
But no, with all due respect, nobody is suggesting that temporary passion or revenge or hatred or repeated criminal conduct is a mental disease or defect. No, there's no evidence to support that. Nobody has suggested
And I don't think there's any harm in telling the jury that. That's really all that says. It just says that temporary passion or frenzy prompted by revenge, hatred, jealousy, envy, or the like does not constitute a mental disease or defect. So I certainly don't see the harm in telling the jury that.
But it's not being supported by any evidence.
I think there's plenty of evidence to suggest that there was temporary passion or frenzy prompted by revenge, hatred, jealousy, whatever one of those things. And I think that's what this jury instruction is asking me to consider. I can look at the comment to be sure, see if there's anything more provided in the comments, but that would be my interpretation of what I'm being asked to consider with those bracketed portions. These look like the same comments that are on all the other instructions in the 600s relating to the NGI phase. Oh, there's a couple of footnotes. Let me look at that. I don't find the footnotes to be particularly useful in the question that's being posed right now. I don't see any issue in reading those particular bracketed items. Frankly, I think I could read all 5 of them. They just aren't really relevant about intoxication because I don't think there's anything that's been discussed about intoxication being a potential issue. In fact, the opposite has come through the testimony. So, anything else you wanted to say in that regard, Mr. Cotton? Or Mr. Eichhoff, I'm sorry.
Your Honor, we're just going to stand on our argument.
Okay. Anything else you wanted to add, Mr. Lassay?
Oh, Your Honor.
I find the evidence supports reading those 2 first bracketed portions, one which I've already read, and then the other one an abnormality, manifested, etc. So I'll include those 2. The next instruction, 110, remarks and arguments of counsel. Any objection?
No, Your Honor.
All right.
And then special verdict questions, number 145, 190, closing, 197, instruction after verdict received. Any objection?
No, Your Honor.
No, Your Honor.
we stand with regard to the verdict forms? Because that does potentially impact instruction 605. So if I'm going to give them more than one verdict form, I would want to explain that. I don't think there's anything suggesting they need to have more than one verdict. I understand the issue. I understand the concern. I also don't want to provide confusion.
I just have one moment to make a phone call on this issue.
Yes, that would be helpful. Thank you.
Is the screen on for the computer?
For you?
Yeah.
No, I don't think it's on you.
Okay.
Do you want it?
Yeah, just to double check that it's.
He's right here. We're back on the record. All right. I've, given some thought to this as well. I think however you want to do it, we can proceed either way. I don't have a problem with asking them to make that finding with regard to each count. What is your final request in that regard then, Mr. Lassay?
Your Honor, I did speak to DOJ. Their advice was we're fine to use the one form and just change crime to crimes.
And your thought?
We agree.
Yeah, I'm okay with that.
I think they could make a decision on different counts if they wanted to, so that's the only thing I wanted to be concerned about. And that's just on the first question. Crimes and then were committed. That's the final request then?
I think so, Your Honor. The likelihood of them differentiating from crime to another, I think, is very limited in this circumstance, given the time frame.
All right, I agree. And so then I think we've concluded our jury instruction conference as well. Kenneth Robbins, right? Mm-hmm. All right, now, when I bring the jury in then, are we prepared to go straight to the defense, or the state putting on their case, and then reading the instructions, closing arguments?
I think we have to put on the record the stipulation regarding the exhibits from the defense, but then yes.
Thank you.
Just so the court is aware, the state has less than 5 minutes of actual clips.
Okay.
Playing them and stopping them, starting them could get us to 10 or 15 minutes.
I just wanted to make the revisions to the jury instructions so that I'm prepared to read them when they come back out. Verdict form revised. You've seen the revised verdict form with at the time the crimes were committed. Any objection to that revised verdict form?
No.
Did you get a copy, Mr. Lissay?
Yes, I answered no also.
Oh, I'm
We
sorry.
just
I
talked at
didn't
the
hear
same
you.
time.
All right, thank you. All right, then please stand for the jury. Please be seated. Thank you for your extreme patience today, ladies and gentlemen. We appreciate it. We took the advantage to make some additional progress in the case. Mr. Cotton has moved exhibits 22, 23, 24, 25, 26 into evidence. 25 has been received. The state has agreed to the admission of 22, 23, 24, and 26. Is that correct?
Yes, Your Honor.
All right. Anything else you wanted to say in that regard?
No, Your Honor.
Correct.
All right. And you rest?
We do.
All right. State?
Your Honor, the state has a handful of audio or video clips that we intend to play by stipulation of the parties.
All right. And are they, I'm sorry, did you say they're only audio?
There's some video, some
Okay.
audio.
We'll turn the lights down.
So we will be moving to mark this thumb drive as an exhibit. This will be exhibit number 20, is it 26 or 27?
27.
27. So then they'll be marked separately as 27A through however far we get.
Okay. Thank you.
So this is exhibit then 27A, and I would note for the record that we are beginning at 4 minutes and 8 seconds into this clip, and we will play until 4 minutes and 20 seconds.
Thank you.
We're at the emergency department.
Hello, Brandon.
We did stop at 4 minutes and 20 seconds. Clip B will be starting at 1 minute and 10 seconds into the video. And we'll play into 1 minute and 38 seconds into the video.
Whose car did I steal? You recording me?
Yes.
Wait, hold on. So is there all there? Like we're in there? Like when when I came in here,
Was it recorded?
was it?
I don't know. I work at the hospital. I don't work for the police.
Okay.
He's part of our security. He works
So,
And that played actually until 1 minute and 39 seconds.
Thank you.
Clip C will begin at 9 minutes and 2 seconds into this video, and will play until roughly 9 minutes and 14 seconds.
You guys recording me on here or something?
I literally just got here. I walked into the. Okay, and that's what I want to talk to you about. So, I just wanted to keep.
I played till 9 minutes and 14 seconds on the video.
Relax, so.
And Your Honor, the next clip will be clip D, and it will play from 36 seconds into the video to 49 seconds into the video.
Was talking about that.
Actually changing it now, that's the name.
Okay. You're reading them.
Okay.
The next clip is clip E, and that is going to start right at the beginning, 0 seconds, and play till 15 seconds.
I went to but the main one, this is the one that I wanted to psychiatrist. And for you to see me, know me, is the Jake's G drive. And there is my wife.
Jake's G drive?
And I played until 18 seconds. Now we are on the audio clips only. This is clip F, and it will start at 31 minutes into this video and continue for about 10 seconds.
Well, we all make mistakes. This is not a good mistake. I agree.
And the next portion of the audio is on the same recording, so this is still exhibit, or still sub E, or is it sub F?
F.
Sorry, sub F. And this will be beginning at 1 hour, 31 minutes, and 17 seconds. So, here we go. Rachel, I'm sorry, can you turn the audio up? Is it up all the way? I apologize because this file is so large, we have to we're playing it with the volume off to get it to the exact point.
Thank you.
psychiatrist.
Psychiatrist, do you think?
That will make them mean things anyway, those stuff. But I think that some of that can relate to videos you have access to.
What's that?
Videos you have access to. They can relate to me on all those stuff. And then it's like you, I think, I might be able to get it down more.
And that played from 1 hour 31 minutes and 17 seconds to 1 hour 32 minutes and 20 seconds.
Thank you.
Madam Clerk, what letter will this one be, the next clip?
G.
G? Okay. Actually, I'm sorry, this is still on the same audio file as before, I apologize. This
So you
is-
just want to reference it as F with a different
Correct.
timestamp?
Actually, this would actually be the third clip on the same exhibit. Okay, so yes, this is F with the timestamp, 5 hours, 2 minutes, and 35 seconds. And we'll play for roughly 30 seconds.
More expensive than Delta there? The mares? Was it just...
Were you looking for Sean?
I think I was looking for a release. I think I was looking to get back to the road or something. I don't know.
I think so too.
Yeah, maybe. Because that's the scary part. If I was looking for Sean, then that's the next closest thing. I just went to what was closest, not what was the hardest to his guy. That's fucked up.
And when you...
And that played until 5 hours, 3 minutes, and 7 seconds. And the final clip is from the same video, beginning at 6 hours, 23 minutes, and 39 seconds. We'll play for about 25 seconds.
Do you know why?
It's something that's totally against what I believe.
And now you have to make it right. Do you know what? This is what happens when we make mistakes.
Let's take vitamin.
Do what?
Let's take vitamin.
Take your what? Take your what, Jake? I don't know.
It played until 6 hours, 24 minutes, and 6 seconds. That was the final clip, Your Honor.
Thank you. Any additional evidence you seek to present at this time?
No, Your Honor.
And you're moving for the admission of Exhibit 27?
We would move for admission, Your Honor.
Any objection?
No, Your Honor.
Exhibit 27, which will be the thumb drive with the video clips A, B, C, D, E, and F, will be received. And the state rests?
Yes, Your Honor.
Any rebuttal? All right, thank you. Ladies and gentlemen, the evidence is now closed. Fortunately, we've already had our jury instruction conference, and we're prepared then to go forward. So at this point, I'd like to read to you my initial instructions on the law. I'll accept a few brief concluding instructions that are better given after the attorneys make their closing arguments. Members of the jury, this case will now be submitted to you in the form of a special verdict consisting of 2 questions. Your duty is to answer those questions which, according to the evidence and my instructions, it becomes necessary for you to answer to arrive at a completed verdict. It then becomes my duty to direct judgment according to law and according to the facts as you have found them. Evidence is defined as follows. Testimony of witnesses given in court, both on direct and cross-examination, regardless of who called the witness. Exhibits admitted by me, regardless of whether they go to the jury room, and any facts to which the lawyers have agreed or stipulated or which I have directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide this case solely on the evidence offered and received at trial. You are to be guided by my instructions and your own sound judgment in considering the evidence in this case and in answering these questions. You should not concern yourselves about whether your answers will be favorable to one party or the other. If any member of the jury has an impression that I have an opinion one way or another in this case, disregard that impression entirely and decide the issues solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The lawyers for the parties have a duty to object to what they feel are improper questions. Do not draw any conclusion for either side if an objection was made to a question and the witness was not permitted to answer. Certain questions in the verdict ask that you answer the question yes or no. The party who wants you to answer the question yes has the burden of proof as to those questions. This burden is to satisfy you by the greater weight of the credible evidence to a reasonable certainty that yes should be your answer to the verdict questions. The greater weight of the credible evidence means that the evidence in favor of a yes answer has more convincing power than the evidence opposed to it. Credible evidence means evidence you believe in light of reason and common sense. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required, but a guess is not enough to meet the burden of proof. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any has been shown. Possible motives for falsifying testimony. and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibilities of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. The court has appointed Kenneth Robbins to examine the defendant and to testify at trial. You should weigh the testimony of Kenneth Robbins as you would any other opinion testimony. You have just heard testimony about the defendant's mental condition at the time of the offense. You will now be asked to determine whether the defendant is not responsible by reason of mental disease or defect. This issue will be presented to you in the form of two questions. First, at the time the crime was committed, did the defendant have a mental disease or defect? Second, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that the answer to that question should be yes. Evidence has greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. The first question is, at the time the crime was committed, did the defendant have a mental disease or defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because of the unnaturalness or enormity of the act, or because a motive for the act may be lacking. Temporary passion or frenzy prompted by revenge, hatred, jealousy, envy, or the like does not constitute a mental disease or defect. An abnormality manifested only by a repeated criminal or otherwise antisocial conduct, it does not constitute a mental disease or defect. If you are satisfied to a reasonable certainty by the greater weight of the credible evidence that the defendant had a mental disease or defect at the time the offense was committed, you must answer the question yes and go on to the second question. If you are not so satisfied, you should answer the question no, and you should not consider the second question. The second question is, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of law? Before you may answer this question yes, you must be satisfied that the defendant's mental disease or defect caused a substantial impairment in his capacity to understand that what he was doing was wrong or to conform his conduct to the requirements of the law. If you are satisfied to a reasonable certainty by the greater weight of the credible evidence that as a result of a mental disease or defect at the time the offense was committed, the defendant lacked the substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law, you must answer the second question, yes. If you are not so satisfied, you should answer the question, no. If you answer both of these questions, yes, the defendant will be found to be not responsible for the offense, and you will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to himself or others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, you are to consider only the issue of the defendant's mental condition at the time the offense was committed. Ladies and gentlemen, as this phase of the trial is in effect a civil proceeding, the unanimity that was required of you in phase 1 no longer applies. Agreement by 10 or more jurors is sufficient to become your verdict. Jurors have a duty to consult with one another and to deliberate for the purpose of reaching agreement. If you can do so consistently with your duty as a juror, at least the same 10 jurors should agree in all the answers. I ask you to be unanimous if you can. At the bottom of the verdict, you will find a place provided where dissenting jurors, if there be any, will sign their names and state the number of the verdict question or questions with which they do not agree. Either the blank lines or the space below them may be used for that purpose. Remarks of the attorneys are not evidence. If any remarks suggested certain facts not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions and your own inferences from the evidence, and answer the questions in the verdict according to the evidence and my instructions on the law. Those are my initial instructions, ladies and gentlemen. As I said, there are a few brief concluding instructions that I will give after the attorneys make their closing arguments. As I mentioned earlier, because the defense has the burden of proof, Mr. Cotton will make his argument first, and then Mr. Lissay will argue his case. And then Mr. Cotton will have an opportunity to present rebuttal argument. But I am going to ask you to be at the table. Yes, thank you. Just given the precautions we have in place. All right. Mr. Cotton, are you prepared to proceed? I am. All right. Thank you. Go ahead.
Jacob Cayer has a profound mental illness. The breadth and depth of the evidence in this case suggests that he is very profoundly mentally ill and a very sick person. I want to talk to you about the evidence you heard today because we're at the second phase of the proceedings, and fortunately it was just one day, and so all of you have had an opportunity to hear really one witness. There was a few audio clips or a few video clips that were played, but you did hear from Dr. Robbins, and I want to talk and summarize just a little bit of what you heard today. It's all fresh in all of your memories, so I hope not to belabor the point too much. As the judge indicated, we have the burden of proof at this stage of the proceedings, which I certainly welcome and accept that. The burden of proof that we have is not nearly as high as the state's burden of proof when they had to prove guilt beyond a reasonable doubt. It's a lower burden, which the judge had read to you, which means that you have to have reasonable certainty, meaning that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required. I don't think anybody can have absolute certainty in a whole lot of things. That's certainly not required. And a guess is not enough to meet the burden. I'm not asking any of you to take any guesses whatsoever at anything. I don't think we need to take guesses in this case because we have such a mountain of material that really helps us understand who Jacob Cayer is and what he was battling with back in 2016 and perhaps the years before as well. A battle that also continues to this day, unfortunately, As you can see, he's not present. You all learned that immediately. He hasn't come in here and testified today. And he appears to have, from what I can tell, no interest whatsoever in this stage of the proceedings. He certainly didn't come in here to try to testify in support of this. And it's been a long road. It's been 4 years. It's been a long road for everybody. What you have seen today, folks, is that the district attorney's office, when the special plea of NGI, you've heard about NGI when that was raised, the district attorney's office went and hired a doctor who I think has impeccable credentials, and I think the state selected him for that reason. Dr. Robbins has been practicing psychiatry for more than 35 years. He's board certified. He's one of the top individuals in his field. He's the former medical director of Mendota, which is one of the mental health centers in Wisconsin. He has extensive experience that he outlined in his curriculum vitae. He's a published author. He's presented on psychiatric topics at various seminars. He's received awards for his performance. Teaches at UW-Madison. He even helped create a program to teach future psychiatrists how to become forensic psychiatrists. And forensic psychiatry is really important because that's the interplay or the analysis of one's psychiatric condition as it relates to the law. That's what Dr. Robbins had testified a little bit about. And he's experienced with forensics. He's experienced with psychiatrics. And what the state did when they hired him is they provided Dr. Robbins with a considerable amount of material. They gave him police reports. They gave him audio files. They gave him video files. They gave him, presumably, all the materials that they would want him to have to reach a fair conclusion. And I certainly take Dr. Robbins at his word that Mr. Lassay, when he made the decision to hire this expert, told him that he wanted a fair analysis to be done. And again, this goes back to our jury selection on Friday. All we ask is both sides here in this case, when we ask you to come in and brave a pandemic and bring yourselves into court to hear testimony in a murder case, all we can ask from all of you is that you will be fair and that you will do your job properly. It's all we can ask, and we trust that you will. And I don't doubt for 1 second that when the state hired this doctor, they were looking for somebody who could provide that fair analysis so that you folks could do your jobs the way you're supposed to. And I don't think it's a difficult call for any of you to make. I don't think this is a difficult, certainly the case itself is an extraordinarily sad case, there's no doubt about that. But in terms of the mental responsibility phase, I think it's very clear what you heard today. What you heard is from a doctor with impeccable credentials who did an unbelievably thorough job in this case. And not all cases are the same, of course. Different cases come in with different amounts of evidence, and different cases have different fact patterns. And as you know, many times doctors do not conclude that such a defense of NGI would be appropriate. In fact, Dr. Robbins himself says that roughly half the time, let's say roughly half the time, he doesn't agree with that conclusion. He tends to take on cases that seem to have some features of NGI, so that really suggests that he can sort of identify which cases might fall into that category. But then even in that universe, only about half of them is he reaching a conclusion that somebody lacks mental responsibility. And the judge had given you the instructions. Of course, you first have to, when you deliberate, decide whether Mr. Cayer has a mental disease or defect. Then you have to decide whether, as a result of the mental disease or defect, did Mr. Cayer lack substantial capacity to appreciate the wrongfulness of his conduct or to conform his behavior. I think what you heard today is clearly the answer is yes, he lacked that ability, he lacked the ability to conform, and he lacked the appreciation of his conduct. No question he had a profound mental illness, probably still to this day is afflicted by it. And we have one of the positive features about this case for you to make your decision is the span of evidence that we have that has existed throughout this case and predates the case. We know that Mr. Cayer throughout his life has dealt with a variety of mental health issues. We know that mental health is not the kind of thing that unfortunately we can just do a blood test and identify somebody as having a particular condition. We're not at that point in science. It's something where we have to look at a person's behavior, we have to look at their functioning, we have to look how they've acted over a spectrum of time, and then we reach that conclusion hopefully through evaluations and through analysis. And very importantly through trial and error, because when you're trying to treat a psychotic condition, as Dr. Robbins said, it's oftentimes uncertain what quantity of medication a person will require to truly get over that and return, we'll use the phrase normal, but to get to a sense of normalcy. And I don't think what you've seen on the videotapes, which are very contemporaneous, these videos that were filmed of Mr. Cayer, are gut-wrenching to watch. Because what you're seeing is somebody really in the throes of a very serious psychotic break that's taking place on camera. And it's continuing. He's fortunately sedated. That's why the doctors did administer the ketamine very quickly to him. And you could actually, I think, see on the tape how he had clearly become more sedated as a result of that ketamine. And the doctors did that for a reason, because they had somebody who was thrashing around, who was disorganized, who was talking completely incoherently, whose eyes were rolled back in his head, who was making statements about whether he ran over people with a car, making statements about who murdered Ike, talking about various women in sort of nonsense theories of how these all connect together. And that's what Mr. Cayer was dealing with then, and I would suggest is still dealing with it now. In a lot of ways, I think he's still grappling with very profound, significant, life, permanent conditions that he'll deal with throughout his life. And with your finding that he lacks, with your finding in support of NGI, Mr. Cayer, as the judge told you, will be committed to that maximum security mental health hospital that Dr. Robbins discussed. It's very much like a prison. The only difference, of course, is so from a security perspective, it's very much like a prison. But of course, the positive feature is that Mr. Cayer will be increasingly medicated as the years go by to hopefully get to a point where the mental health issues are brought under control and the level of violence is reduced accordingly. I think it's very tough for Mr. Cayer's family and Mr. Cayer himself to deal with this, and it's obviously very tough for the Teague family and Mr. Kennedy, the horrors that they have to go through. Everybody here has really gone through horrors, I would say. But we can't let emotion of the horrors control the decision that you've sworn to make. And the decision you have been sworn to make is to listen to the evidence and find Mr. Cayer, find that NGI is supported when the evidence supports that. I think Dr. Robbins, if we look at just the mountain of things that he looked through, let's start with the competency evaluations. Within roughly 30 days of this crime taking place, Mr. Cayer has a competency evaluation that was done by Dr. Lee. And that right away, right out of the gate, doctors are noticing, lawyers are noticing, people in the court system are noticing that something is profoundly wrong here. And when Mr. Cayer gets committed, he's restored, as they say, to some level of competency. As Dr. Robbins said, it's a very low threshold, somewhat of a low threshold to get him to a point where he can understand the proceedings and be present in court, and that did happen. And then you heard that as time went by, until there was further evaluations, Mr. Cayer decompensated as one might expect, and was numerous additional doctors began evaluating him again. Mr. Cayer was sent back to Mendota, and for the length of time that he was at Mendota, every doctor who evaluated him agreed uniformly that he was extraordinarily psychotic, that he has a psychotic condition. Eventually, we had a report from Dr. Landis that you heard about today, and then the report from Dr. Robbins, both of which conclude that Mr. Cayer is schizophrenic. Now, as you heard, oftentimes schizophrenia is not something in men that can materialize at a younger age, but it usually doesn't. And Mr. Cayer was 26 years old at the time this happened, and his mental health unfortunately crescendoed in this moment, and that's what brought him into the attention of the mental health professionals in an institutional setting. But it's very clear that there had been something amiss and things wrong throughout Mr. Cayer's life, going perhaps even as far back as second grade, where doctors had diagnosed certain conditions. He was given a personal aide that was present at all times. And then you heard testimony about the sheer quantity of medication that he was prescribed even in those high school years. One of the things that obviously happened in this case is that Mr. Cayer was not on his medication at the time this offense happened. You know from the blood results in this case, you heard testimony from Dr. Robbins that the blood results came back demonstrating that there was no antipsychotic drugs in his system. Similarly, there was no illicit drugs in his system. And that's a very important factor because, as Dr. Robbins said, something like a hallucinogen or a stimulant could produce a certain reaction. You have no impairment whatsoever in this case. All of the behavior you were seeing was the product of an unmedicated schizophrenic condition. There hasn't been any conflicting testimony whatsoever presented today to rebut Dr. Robbins' conclusions. None. No competing doctor. The doctor that was brought to you, appointed by the court, hired by the district attorney's office. That is the extent of the testimony that was introduced in this phase of the trial. And I would submit that that absolutely meets the burden of proof on the lower standard of greater weight of the credible evidence. Dr. Robbins versus a few video clips. I think we overwhelmingly met our burden of proof, and I hope you'll find the same. I'll get to give a rebuttal speech or a rebuttal presentation after the state because I have the burden of proof here. But I want to talk a little bit about what I think the state's theory is. I think the theory here is that Mr. Cayer is faking mental illness or that he is putting on a show somehow. And I think the evidence is so abundantly contradicts that concept that I almost would rather hear it before I address it. But I want to talk just a little bit about it. Every single evaluation that's happened with Mr. Cayer, he has persistently rejected the notion that he is mentally ill. Every single time, including probably in court when he testified the other day, but certainly when he met with Dr. Robbins, who was hired to do an NGI evaluation, every single person who's interacted with him in a professional capacity, Jacob Cayer has insisted, I'm not mentally ill. I am not mentally ill. And then he weaves in a theory about some interconnection between three women and nonsense theories about being ganked and all this other stuff that he is delusional about. They're all delusions, apparently. But he is persistent. He's not mentally ill. This is the exact opposite of a person who is trying to convince you to commit him because he has a mental illness. He's fought that every step of the way throughout his life. Even one of the tapes you saw, or one of the tapes in this case, he's been arguing with medical professionals when they bring up psychiatric conditions. So I don't think the evidence supports the notion that Jacob planned out this crime, planned to commit this offense, was done in such a haphazard, inexplicable way, with a long knife still in his backpack and no attempt to conceal anything and no real attempt to hide himself or wear gloves or anything. It's just a very sort of senseless, inexplicable thing. And Heesun it just doesn't make any real sense whatsoever. There's no real attempt to flee. But it doesn't appear to be founded in reality that Mr. Cayer is faking any of this mental illness. I think he truly, in his mind, because he's not medicated, he believes that he doesn't have anything wrong. Even when he went to Mendota, when he was committed, what did he do there? Refused to take medication, told the doctors he's not mentally ill, despite medical professional after medical professional explaining that he is. And it wasn't until the doctors actually put someone there to physically monitor him to make sure he takes the liquid medication, it wasn't until then that he even actually would take it. So I don't think he's in a good state now. I think that the way he is right now is very early in what needs to be a very long-term treatment plan that will take place in his life with significant quantities of medication administered over the years. But I don't think that there's any evidence that Mr. Cayer has concocted anything. I think that in his mind, the delusional theories he's offered are fixed, something that he thinks truly happened. But as Dr. Robbins explained, that's what delusions are. They're fixed, firm beliefs that are impervious to people, to rational evidence that's presented against the person. So what did Dr. Robbins conclude? He's highly experienced. He's highly respected. He's done this type of work for 35 years. He's hired by the state. He reviews literally everything, extraordinary amount of evidence and videos and audio and reports and summaries. And Dr. Robbins concludes that Mr. Cayer was so impaired because of his psychotic condition that he could not conform his behavior to the requirements of the law. Now, I think if you had a doctor who just came into a case after 4 years and reached a conclusion without any real history, that might raise some questions. But when you have the quantity of competency evaluations, just look at the competency evaluations that have taken place throughout this case. Multiple doctors seeing Mr. Cayer throughout the 4 years that this case has been pending, including a doctor within 30 days of the incident, and even video, interestingly enough, video that's filmed of Mr. Cayer in the exact hours or minutes after this offense took place. So this isn't a situation where a doctor is just offering some random opinion sort of detached from reality. This opinion is well-grounded. It's founded in all the evidence in the case. It's based on a thorough review of Mr. Cayer's comments, his behavior, his patterns of behavior, his speech, the words he said, the competency reports that uniformly identify serious, profound problems with him, the psychiatric history that's existed throughout much of his life, the behavior that night. And so that's a conclusion that I think should be given the weight that it deserves. You should find yes on both of the questions that are asked of you. Thank you.
Thank you, Mr. Cotton. Mr. Lasay?
Defendant's lack of understanding as to the state's position is frankly consistent with Dr. Robbins' lack of understanding of the facts of this case and his lack of understanding of what he needs to do to actually demonstrate the burden of proof that's before you here today. The state is not arguing, and nobody is arguing, that Mr. Cayer is totally fine, that there's nothing wrong with him, that he doesn't have any mental problems. No one's making that argument. How could we? How could anyone make that argument with a straight face? You saw him. You observed him. That's not the legal standard. If the legal standard was get a doctor, have the doctor make an evaluation, and have the court make the decision based on the doctor's evaluation, we wouldn't have a jury hear part 2 of this case. It's not the doctor's opinion that matters. It's your opinion that matters. You were instructed, and you'll be instructed again. You'll have those instructions back with you that you give that doctor's opinion the weight that you give the opinion of anyone else. Is he credentialed? Is he an expert? Does he have good character? Yeah, absolutely. And the state did retain him, presumably because he's good at his job. There's no question about that. But his role is not to decide Mr. Cayer's fate. His role is to offer you an opinion for you to consider in light of all of the other facts and circumstances of this case. Don't let Mr. Cotton convince you that you only heard from one witness today and that's all that matters. There's a reason why this is a 2-phase trial with the same jury, because you heard all of the other evidence in this case. And all of that other evidence in this case can and must be considered in this phase as well. You know what you heard, you know what you perceived, and frankly, you know a heck of a lot more about this case than Dr. Robbins does. It is completely disingenuous to suggest that he reviewed literally everything in this case. On cross-examination, it was abundantly clear that he had not reviewed some of the most essential pieces of information in this case. He didn't see how Mr. Cayer reacted just minutes after this crime when he's taken into custody by law enforcement. He didn't actually see and perceive and witness Mr. Cayer throughout the course of his interview with law enforcement hours later. He basically watched the clips from right when he arrived at the hospital. And there's no doubt those clips are disturbing. They are. They clearly show somebody who is in distress or is pretending to be in distress or is exacerbating his distress at that particular moment. They don't show you what Mr. Cayer was doing 2 hours earlier. When Joel Kennedy describes him as calm, cool, collected, not saying anything, hiding in the closet, having planned out these murders, having snuck into a house, ripped out the phones from the wall, killed Sonny Teague, and lie in wait for his other 2 victims. And frankly, Dr. Robbins' suggestion of while he was laying down in the grass near the house, it demonstrates his lack of understanding of the facts and circumstances of this case. He doesn't understand how that took place. He didn't see the maps. He didn't hear the law enforcement officers testify. He didn't know there was blood on the bike. And Mr. Cayer may have gone out there, tried to get off the scene, and then ran in the back. He doesn't know that he tried to get in the back room and attack Joel Kennedy. In fact, he mocked Mr. Cayer's leaving a surviving witness as a scene as bad planning and as demonstrative of his failure to understand what he was doing. He broke through the bedroom door to try to get at Joel Kennedy. He knew what he was doing, and he gets there and he hears Joel on the phone with 911 and he takes off. That's a person who understands that what he did was wrong, that there will be consequences for his actions. He goes into the woods and he hides until police find him. And how does he react right when the police find him and he's got that dog biting him? He didn't have any confusion. He didn't have any difficulty thinking. Show me your hands. I give up. Where's the knife? It's inside. I don't have it. And he told you why he said that, actually. He said on that stand and he told you because he's afraid law enforcement officers might shoot you. So that's what's going through his mind. Oh, wait a minute. This could be a problem here if I don't cooperate. I know I'm covered in blood. I just killed these two people. Law enforcement find me. I better tell them. I give up. Knife's in the house. No confusion. No problem thinking. He knew what was going on. He knew what he did was wrong. And equally important is all of that 8 hours of video that Dr. Robbins didn't think was important enough to listen to. He's making a decision about Jacob Cayer's mindset on June 7th, 2016, but he didn't listen to the audio recordings for 9 hours immediately after that crime. And his failure to acknowledge that Jacob's saying countless times that he's sorry, that he fucked up, that he didn't want his mom to know that he was going to be in the news, that he hoped that nothing had happened to Sonny, that it's unfortunate what happened to Sonny, asking about Sabrina, seeing if she's okay. He knew what he did was wrong. There's no question about that. That element isn't even close to being met. And when we asked Dr. Robbins to support why he had that opinion, his response was frankly absurd. It was irresponsible. He suggested that, well, there was a lack of planning. You know how many murders are committed with a lack of planning? You think people that walk up on a house and they shoot somebody in the middle of a drug deal, they planned it out, and they planned out their escape? That's not an NGI defense. That doesn't meet that prong. He gave you nothing. He gave you a litany of information about mental illness. I don't deny that. A litany of information, and he spent a ton of time. Ask yourself about his testimony here today. He was on the stand for almost 3 hours. 2 hours and 45 minutes of that was talking about his mental illness. And that's fine. Answer yes to question 1. Not everybody with a mental illness is NGI. Not everybody with a mental illness doesn't have the ability to appreciate the wrongfulness of their conduct or conform their conduct to the law. And ask yourself about that second phase. 10 hours after this homicide, Jacob Cayer is given a pen and he's got it to the neck of a law enforcement agent. He's got no problem conforming his conduct. When the officers get on the scene and they have the dog and they're telling him to comply, stop resisting. Where's the knife? It's inside. I give up. He's conforming his conduct to the law just fine when it suits him. He's not conforming his conduct to the law when he's mad. When he got in a fight with his dad and he's riding his bike through all the hell that's going through in his life. He had a motive to kill Sabrina Teague and her mother because he was upset. His family life has fallen apart. This woman, and Dr. Robbins is the one who tells us, this woman was over at his house talking to his mom while he was in jail, telling him about a sexual assault allegation. And in the statement that he makes to Sergeant Holzbach, he talks about that. And making his mom cry on top of everything else. Dad's mad at me. Now mom's not on my side either because she's crying because of this allegation. And he's pissed off at the world. He's mad. He's upset. The rage is boiling over. And he goes to who's closest. Gets on his bike and he rides 30 minutes with a backpack full of killing implements or repo things or whatever it is he wants to classify them as now. And he walks into that house. He breaks in through the bedroom window. He didn't walk through the front door. This isn't a random house. He drove from Cormier to Hobart. That's not a random act. This is not some person who's just wandering down the street and happens to hack up the first person that he sees. He goes to an ex-girlfriend who made an allegation of sexual assault against him that he disagrees with. And his life is falling apart and he's mad and he drives to her house on his bike, miles away. and he breaks into the house and he kills her. He kills her after he killed her mom. He lied in wait for the two of them. And he made rational decisions to get out of there when law enforcement is coming. You were given precious little information about either of the two prongs in Part 2. Lots of information about mental health. And the state doesn't contest that he's got a mental health issue. He's got a mental health issue. He's got a mental illness. The issue is those other prongs. Does that mental illness render him substantially incapable of understanding the wrongfulness of his conduct or conforming his conduct to the law? And he sat there on that stand, and I understand he doesn't think he's mentally ill. And he might be wrong about that. I think he probably is mentally ill, but he doesn't think he's mentally ill. But he did explain to you he doesn't take responsibility for these actions because he knows they're wrong. If he really didn't appreciate how wrong his actions were, why is he so adamantly opposed to the fact that he did them? Why does he create a delusion in his mind about what really happened, an absurd delusion, to cover up for the fact that he won't accept responsibility that he's done this? Because he knows that if he did do it, it's awful. It's awful. Just like he said in his statements to Zach Holzbach, I hope I didn't do this. Who did I kill? What happened? What happened here? And even just the manner in which he discloses to law enforcement, it's quite clear he knows what happened because he gives you snippets over the course of that night. Right? He admits 20 different facts that are corroborated by the evidence at the scene about what happened. So he knows what happened. But he discloses it in a manner to law enforcement that suggests that I can't really tell him all of this because, man, this is bad. I fucked up. I made a mistake. I made a big mistake. Not just a mistake, I made a big mistake. He knows it's wrong. He knows about the mistake that he makes. And that's why he won't disclose it right out. He has to disclose it piecemeal because he knows how bad it is. There's no question he knew what he did was wrong. And I want to return to those videos that you saw getting off the ambulance because they are disturbing. They're disturbing videos. But none of the other interactions that any of the professionals or this court system, this court right here, you saw him testify. None of those are consistent with what you saw in those videos. Those videos, he's non-functioning, he's rolling around, he's thrashing until he sees the cameras rolling and he goes, "Oh, you filming? You filming me? You recording me?" He asked 5 different times, "You recording me?" He wants to be recorded. He wants you to see that. And there's no doubt that he had been through substantial trauma at that point when he gets out of that ambulance, right? He just murdered 2 people, tried to kill another, hid in the woods, chased down by a dog, bit, brought to the hospital, and he knows what he did. He knows what he did. There's emotional stress and trauma that goes with that to exacerbate what he might have for mental illness before that. And again, I don't contest that he has a mental illness. There's no question about that. But none of the interactions that we see from these other doctors and the interactions we saw on the stand are consistent with that level of just not understanding what's going on around you or being disoriented. He's confused, but his thought process is quite different. You saw his thought process. You saw how he testifies and appears in court. And that's the same thing that Dr. Robbins describes. He comes across as grandiose, as arrogant, right? And he's a business owner. His business is, of course, repoing stolen items, apparently. But he comes across as knowing more. He needs to help Mr. Johnson tie his shoes, right? But that level, that mental illness that you saw displayed is not consistent with what you saw in that hospital. That's completely different. So to the extent that we think he's playing up his mental illness, maybe in those videos, right? I don't deny that he has a mental illness, though. I don't think this is a falsified claim of mental illness overall. But certainly there's a suggestion that he may have been playing up what's happening at that hospital a little bit. Because very quickly after this offense, very quickly after he gets to the hospital, he's completely different. None of that is happening. Right? And there's administration of ketamine, but he gives a 9-hour statement to law enforcement officers, just outlining many, many different aspects of this crime. He rode his bike to the Teague residence from miles away, wants you to believe that he just ended up there and doesn't remember how. But he intentionally went there based on the information we have. It's his motive. He was pissed off. She was part of the problem. He brought his backpack with him. It contained the items that he needed to kill. He broke into the house through a window. He's pissed off at his dad, but he doesn't stay at that residence and fight with his dad because he knows he doesn't want to do that. He goes somewhere else. It shows an intention, a plan to go somewhere else and do this. After killing Sonny, he washes himself. He washes his feet. He washes his socks. He cleans off the blood. He steals Sabrina's phone. He rips the phone out of the wall. He takes the batteries off the other phones. He tries to chase Joel into the bathroom, breaking through the bedroom door. Hears him on the phone with 911, and he takes off and he hides. Law enforcement find him, and he immediately and coherently responds to them about the knife and says he gives up. These are not the actions of a person who doesn't understand that what they've done is wrong and can't conform their conduct to the law. He can when it suits him. He can when he's not angry. And that's what you're asked to consider here today, not whether he's mentally ill. Those two prongs are also important. It's not just mental illness. You have to know that those other things are present. And frankly, Dr. Robbins has done little or nothing to explain that to you. And I just want to reiterate that the 12 of you make this decision. That is what the law dictates. It is not for Dr. Robbins to decide. It is for the 12 of you to decide whether Mr. Cayer escapes the consequences of his actions based on his mental illness. It is up for you to decide whether they have met that burden, because it is now their burden. I submit to you that they have not. They've done next to nothing to explain to you why those second prongs exist, either of them. And all of the evidence that you heard over the course of the previous 3 days directly contradicts that. And for those reasons, I ask that you indicate that no, Mr. Cayer does not substantially lack the capacity to conform his conduct to the law, and he does not substantially lack the capacity to appreciate the wrongfulness of his actions. Thank you, ladies and gentlemen.
Thank you, Mr. Lassay. Rebuttal, Mr. Cotton?
Mr. Lassay indicated that we're being disingenuous. He called our arguments disingenuous. I think the state's being disingenuous. I think to suggest that when they hire somebody like Dr. Robbins to do an evaluation, when they provide all of the materials to him that he's to rely on, when they say, we want you to reach a fair conclusion, and then they provide him with all the materials that they think he needs to reach a fair conclusion. And then he reaches a conclusion that doesn't support what they want, apparently what they want him to reach, which is to reject NGI. They should have just said to him right out of the gate, we're really looking for somebody to reject NGI, because if they wanted a fair analysis, they got it. They gave him all the materials. He drafted the report, he studied all the evidence, and he reached a conclusion. And there's a suggestion here that somehow we are the ones that are being disingenuous. We haven't done anything disingenuous. That's their doctor that they hired to do the evaluation, and he reached a conclusion that is well-founded and well-grounded. The state's suggesting that he's done next to nothing to support his conclusions. If the state didn't like the conclusions of Dr. Robbins, then go and hire another doctor. Go hire somebody else.
Sustained.
The state's suggesting he didn't do a thorough evaluation when they're the ones that give him all the materials. When he goes back through, even recently, Dr. Robbins going to Mendota to study, even after he did his report, to go back and study additional mental health records from Mendota. The only reason he did that is because he wanted to make sure he was abundantly thorough with his conclusions. Yes, of course, Mr. Cayer has a mental illness. We spend a lot of time talking about it because it's very important for you to understand that. But a person with schizophrenia, which is a profound mental illness, it's a mental illness that results in delusions, hallucinations, as you heard Dr. Robbins testify to, that type of profound mental illness is so extreme that it does result in people losing the ability to conform their conduct to the requirements of the law. Nobody here is suggesting Mr. Cayer escape consequences, these buzzwords that are being tossed at you, that he wants to escape consequences. Nobody's escaping anything. Mr. Cayer, if you find NGI in this case, which the evidence today presented supports that, if you find that in this case, he goes to a locked maximum security mental health quasi-prison. And there's a multi-layer standard in place for medication to be administered for however many years that'll happen. And if sometime ever occurs that they think he's not dangerous, it can be petitioned to a judge who can still make a decision to choose to keep him in an institution. That's the system that exists in this country, because we recognize that people who have profound mental illness like Mr. Cayer ought to be treated, ought to be medicated, still confined, still being held accountable, in every respect being held accountable. Throughout the remainder of his life being held accountable as he's medicated and as he sits in a maximum security institution. And as Dr. Robbins said, most people who juries find NGI, most people at Mendota spend more time there through a mental commitment than they do in prison through the other route. So nothing about this is escaping any effort to escape consequences, and it certainly doesn't even appear to be something Mr. Cayer is particularly interested in. It's just the right thing to do given the evidence in this case and given the expert they hired to give the analysis. Of course it's your decision as jurors. That's why we presented Dr. Robbins to you. That's why we have this phase of the trial. Of course it's your decision. But you're to compare the evidence that's presented in this phase of the trial as well. So if the state has additional evidence to rebut Dr. Robbins' very comprehensive conclusion, then they have an opportunity to present it. And when you go back to deliberate, you can compare the evidence. What you heard from is their expert supporting the plea in every respect. And remember, it is important to remember that there are two questions: the mental illness, did Mr. Cayer have a mental disease or defect? But question number two, it is important to remember, has two parts. The state talked about Mr. Cayer appreciating the wrongfulness of his conduct, that he could appreciate that what he did was wrong. Perhaps he could, but the question is whether he could conform his conduct to the requirements of the law. And that's what Dr. Robbins was explaining with schizophrenia, that it crescendos, that a person with this profound mental illness, it builds up over time, and we eventually see exactly what we saw in this case, a complete explosion, and that's the inability to conform the conduct. That's what he was testifying to, not whether Mr. Cayer knows or appreciates that it's wrong to kill someone, although perhaps in that condition he was in at that point, he lacked that as well. I think you can make that finding too. But there are two separate questions within that question. Mr. Cayer's future conduct was something the state talked about, or his future behavior. Again, within 30 days of the charges being issued, he's committed to a mental hospital for restoration of competency. So he gets medicated on some basic level to improve his functioning somehow, some limited amount. So there is some amount of medication that was provided, but it's nowhere near optimal. The person that you saw testify on the stand, I don't think, was a particularly compelling witness. I didn't ask him about his mental health history because I didn't think it was relevant at that stage. But you saw him, and I agree you should consider that. And you should consider all of the evidence. Consider the statements that he made right after this incident. Consider his confusion. Consider his disorganization. Consider the screaming, the twisting, and the gut-wrenching videos that are filmed almost contemporaneously with the crime. That is the type of person that committed this offense. It was his schizophrenia that crescendoed and resulted in this happening. So I would ask that you do your job the way that you're supposed to do your job. Yes, you do make the decision, but the evidence that was presented today was convincing and did meet the burden of proof that Mr. Cayer has a mental illness and could not conform his conduct on that day. Thank you.
Thank you, Mr. Cotton. Some questions in the verdict are to be answered only if you have answered a preceding question in a certain manner, ladies and gentlemen. It is important for you to read any introductory portion of a question carefully before you answer it. Do not answer questions you are not required to answer. Now, members of the jury, this case is ready to be submitted to you for your serious deliberation. You will consider the case fairly, honestly, impartially, and in the light of reason and common sense. Give each question in the verdict your careful and conscientious consideration. In answering each question, free your minds of all feelings of sympathy, bias, or prejudice. Let your verdict speak the truth, whatever the truth may be. When you retire to the jury room, your first duty will be to elect a juror who will preside over your deliberations and write in the answers you have agreed upon. The vote of the presiding juror, however, is entitled to no greater weight than the vote of any other juror. When your deliberations are concluded and your answers inserted in the verdict, the presiding juror will sign and date the verdict, and all of you will return with the verdict into the courtroom. Thank you for your attention, ladies and gentlemen. At this time, the clerk will now swear the bailiffs.
Did you swear that you will, to the utmost of your
Excused from the courtroom to go to branch 1 to begin your deliberations. Please stand for the jury. If you would take your notes with you. Please be seated. Counsel, are there any objections to the instructions as I read them?
No.
All right, and I think we talked about this already. Maybe we didn't. I can't recall. Any objection to sending all the jury instructions into the jury?
No.
Okay. And then we'll wait and see if they have any requests for exhibits. Anything else at this time?
No, we'll be nearby.
All right, thank you. Just like yesterday, if you would be no more than 5 minutes away and leave a cell phone with the clerk. Thank you. We'll be in recess.
Now, you know to destroy that after this is over, right?
Yeah.